بسم الله الرحمن الرحيم وصلى الله وسلم وبارك على سيدنا محمد وآله وصحبه. In the name of Allah, the most gracious, the most merciful, and may Allah's prayers and peace be upon the Messenger of Allah, his family and companions. Ladies and gentlemen, dear viewers and online attendees, I warmly welcome you to all. I warmly welcome you all to this second academic session of the fourth scientific conference organized by Imam Abdessalam Yassine Foundation for Studies and Research under the theme Human Rights between Ethical Imperative and Utilitarian Instrumentalization. In this session, we are honored to host a distinguished group of scholars from Morocco and India, who will be presenting their research papers and reflections on this pressing subject. As scholars of Usul al-Fiqh say, occasion determines the ruling, al-munasabatu shart. And indeed, this conference convenes at a moment when human rights are being brutally violated in the besieged and bleeding Gaza. Since October the 7th, the Zionist entity has unleashed a campaign of devastation and destruction, leaving no trace of life untouched in Gaza. Children are being bombarded. Children are being bombarded with fire from the skies, killed in cold blood. But who cares? Entire families are being whipped from civil registries. But who cares? Doctors and paramedics are being assassinated in hospitals and ambulances. But who cares? Schools, universities, and mosques are being reduced to rubble. But who cares? Not a grain of wheat, not a sip of water, not a single tablet of medicine is allowed into Gaza. But who cares? Gaza today is a test of our humanity and moral integrity. The very nations that have deafened us for decades with rhetoric on human rights are now complicit in trampling those very rights and in dehumanizing the people they claim to protect. In light of this grim reality, it is necessary to pose difficult yet essential questions. Yes, there is a United Nation. There is a United Nations. But united for what? And against whom? Yes, there is a Security Council. But whose security does it guarantee? Yes, there are human rights. But for which humans? Gaza has laid bare the hypocrisy of a world that claims to be free and democratic. As Imam Abdessalam Yassine, may Allah have mercy on him, once stated, I quote, "The greatest human right is for a person to know his Lord. The greatest human right is for a person to know his Lord." This notably is absent from the Universal Declaration of Human Rights, issued in 1948. He also wrote in Sunnatullah, his book Sunnatullah, human rights are an expression of noble character, and we are Muslims. We are more worthy of upholding their banner. This conference is taking place amid one of the most painful and trying moments our Ummah has witnessed in recent history. Our besieged brothers and sisters in the small strip of Gaza are being slaughtered, and this heightens the urgency and relevance of revisiting the questions of human rights. Without further delay, allow me to introduce the first speaker of this session. Please join me in welcoming Dr. Muhammad El Ghazi. Muhammad Al Ghazi, after holding a PhD in linguistics from Mohammed V University in 2005, Dr. Al Ghazi has served as a professor of linguistics at Ibn Zohar University in Agadir, Morocco, for over 25 years now. He specializes in subjects of morphosyntax, language policy, and sociolinguistics. He currently serves Vice Director of the Laboratory of Values, Society and Development, LVSD, coordinator of the MA program in linguistics, and supervisor of a university English training program for educational and administrative staff. As a researcher, he has regularly published one multilingualism. As a researcher, he has regularly published on multilingualism, Amazigh language shift, and Arabic syntax. Authored numerous journals, articles, and edited four books for book series under the main title of Language and Current Issues. He has supervised multiple master's and PhD theses and organized international conferences on multilingualism, education, and identity. Previously, he held leadership roles as head of the English department and university council member, combining academic pertinent activities with institutional governance. Mr. El Ghazi's paper is about beyond legal frameworks, how societal factors shape women's rights in Western and Muslim majority nations. The floor is yours, Mr. Al Ghazi. You have 15 minutes to present your paper. Go ahead.
Thank you, Professor Dr. Lahsen Shuaib. It's a honor to be among you today in this
Mr. Ghazi,
international.
are you with us?
Yes, yes. Can you hear me? Yes. Can you hear me?
Oh, the floor is yours.
Assalamu alaikum. Can you hear me, Sir Lahsen? Yes. Can you hear me?
Yes, yes, I can hear you now. I think you had a technical problem, but now we can see
Maybe,
and hear you. Go ahead.
maybe. So thank you, uh, Dr. Lahsen Shuaib, for your kind introduction. And it's a pleasure for me to participate in this interesting and very insightful international conference on human rights, especially in these days in which we see that human rights are flagrantly uh, flagrantly say not observed. My intervention, my participation is about the how the official discourse in Western countries does not reflect the real or the reality of human rights at a social level. So that's why I entitled my presentation as this: Beyond Legal Frameworks, how societal factors shape women's rights. In this presentation, I'm going to compare between Western societies and Muslim majority nations, especially when it comes to women's rights. The paradox that I have witnessed through my recent readings goes as follows. In the common views and the global discourse, it is often assumed that Western legal systems automatically entail that there is a kind of advanced protection for women's rights. In fact, it is clearly observed that in Western nations, there are strong legal systems of human rights. However, in some Muslim majority nations, despite the weakness which is witnessed at the legal systems pertaining to human rights, we still find out that there are stronger de facto or practical outcomes in areas pertaining to women's rights, especially in physical safety, educational attainment, and the economic stability of women in crisis. So this presentation explores the paradox and we argue that culture and religious factors compensate for legal gaps that exist in the Muslim majority nations, while systemic issues hinder Western implementation. The statement or the thesis statement which is advanced or which is supported and argued for in my presentation is the following. While Western societies have advanced de jure rights, many Muslim majority nations exhibit more favorable de facto outcomes in specific areas due to the compensatory role of religious, cultural, and familial norms. This simply means that the existence of official legal texts is not sufficient or a sufficient condition for favorable human rights protection. It is found out that effective rights realization depends significantly on socio-cultural and religious factors. To argue for this thesis, we have organized the presentation as follows. First of all, I have a brief comparison of legal frameworks in the West and in the Muslim majority countries. Second, I will examine the practical outcomes, the paradox which exists between the two contexts, and then I will try to explain the reasons for this discrepancy on the basis of cultural, religious, and individualism in the West. In the fourth point, I will introduce a potential remedy framework based on Imam Abdessalam Yassine's comprehensive theory of religious revival, which is called Al-Minhaj al-Nabawi. Then, finally, I will conclude with a recommendation for a proposal in which we call for a human rights hybrid model based on this theory of Islamic revival. So, to go directly to explaining the paradox, as I said, it has been witnessed that there are differences at the level of the legal systems pertaining to human rights in the West and in some Muslim majority countries. So, of course, in the West, the legal systems of human rights are more advanced on the papers in these countries, whereas in so many Muslim majority countries, especially in the Arab world, these laws are still creeping. They are still trying, okay, to reach the standards which are imposed and called for by international agencies. So in Western, okay, countries, however, when we come to the practical and the outcome in reality, I have, okay, found some statistics which are really shocking. So despite the advancement they have theoretically at the legal systems, we find the higher rates of violence against women still persist in these countries. For example, in 2014, 1 out of 3 women were reported to have been violenced, okay, and harassed in so many European countries. In France, for example, in 2019, 146, I repeat, 146 females were intentionally killed because of their gender. 146 cases of killing because of gender in 1 year. In Sweden, okay, which is famous of its social welfare and which is known as one of the most prosperous countries in Europe, it has been found that 38.4 per 100K, which means 100,000 cases of violence against women were reported. 38.4. Okay? In 100,000 cases were reported to have been, okay, violenced against women. These statistics are due to the United Nations Office on Drugs and Crime. Whereas we find, for example, in the Arab world, and I invite the audience to compare this huge difference between these statistics. In Arab countries, okay, only 0.3 cases were reported. So compare 38.4 to 0.3 cases of violence against women were reported. Okay, so in Europe, as I said, there is that kind of robust and strong legislative systems protecting human rights at the level of, okay, the constitutions and legal systems. Whereas in reality, what happens to women in everyday life, it's something which is totally different. Those legal or those strong legal systems could not protect women from being tortured. Again, when you go to family safety, okay, the family normally in so many Arab countries or majority Muslim countries, family supports women from destitution, especially if they are divorced or widowed. And we have so many cases in the Arab world, in the Muslim countries, where, okay, and by the way, the statistics again are due to World Bank, okay? They have reported that, very, very, very considerable, amount or number of women were protected by the family and by society, not by governments, by the way, not by governments, but by, social networks. Again, concerning the representativeness of women in the legislative institutions, there is a great difference between Western countries and so many so-called backwarded countries. In the United States, for example, we only have 27% of female representatives in the US Congress. 27%. I repeat, 27% of female representatives in the US Congress. Whereas in Rwanda, which is a very backwarded country, there are 61% of female representatives, more than a half. In the Emirate, United Emirates, we have 50%, even though it's a very conservative country. We have 50% of women, This doesn't mean that I am uprising these political regimes. I'm just giving the states and the statistics as they are, on the basis of very well recognized international institutions like the World Bank. And then now I move to the following points, which is how can these paradox result be explained? What account can be given? And I have relied on some quotes from Fatima Mernissi, 1987, and Ahmed, 1992, and then, on the basis of other reports from the European Union. So the financial situation of women, divorced women or widowed women in Muslim majority nations is much better than the situation of divorced women in some Western countries, on the basis of 2 or 3 main factors. First of all, the respect which is given or which is due to the women's property, because of the Islamic teachings, a woman have the right to preserve and to keep her property for herself, and no one, even her husband, has the right to take it from her. Again, the system of inheritance, which is much criticized, is one of the factors that has been reported to be the source of the wealth that the women in these Muslim majority countries have, which is much better than, as I told you, which is much better than the situation of widowed and divorced women in Western countries. Again, there is that kind of protection which is granted by the male and the family to the females in these countries, in these nations, because of the concepts such as honor, al-ird, protection against risks. So men in general, the family, they try to protect their kin women in critical situations. Again, in these countries, there is the emphasis on education via Islamic values to some extent. To some extent. So people still persist to those Islamic values which call for the respect of females, of women in general, regardless of the secular legal texts of human rights. The paradox, again, can be explained, via other or through other concepts, such as the concept of that we have, especially in some North African countries, of hshuma, which is a kind of being, trying to, it's like al-ird in the Middle East. Okay, so people still try to preserve some rights of women at the, I say again, at the social level, not at the official level. That's why we have those discrepancies in the statistics that they have given, and there are much more. The third point, or the fourth point I move to, is the proposed remedial framework, as I said, which is advanced by Imam Abdessalam Yassine to improve, and first of all to safeguard, and then to improve that situation in which society protects women's rights, and not the legal systems, and not the human rights articles. So Imam Yassine rahimahullah proposed a holistic approach via spiritual and ethical transformation, which is called the tarbiyah, the education of society. His critique of the existing systems is advanced or faces two main sectors. First of all, the secular rights lack moral grounding, since they are human-made and not divine. Again, the authoritarian regimes manipulate religion to their benefits. That's why we have to depend on the popular belief, on the popular implementation of those religious principles
Mr.
on the
Ghazi,
behavior with women. Yes.
I think you exceed the 50 minutes we gave to you. You talked for 70 minutes now, and we do have to move to the second speaker. I'm sorry for this, because
can I just conclude by that hybrid model I said before? Okay. Anyway, I just conclude by saying that
in less
yes,
than 2 minutes,
yes,
please. Less than 2 minutes.
yes, the legal superiority of the legislative system in some countries doesn't necessarily mean that there is a kind of paradise for human rights in those societies. There is sometimes the legal superiority doesn't can give adverse and contrary results. So the effectiveness of should be mediated by of those systems should be mediated by the culture, religion, and social structures, economics. Lessons that we draw from this, that Muslim majority societies show power of informal culture protections with some limits, whereas Western societies show laws that need to be supported, and to be added, to be supported by some cultural and religious structures. Thank you very much, and I'm sorry for exceeding the time which is allotted to me.
Okay, thank you, Mr. Ghazi, for your presentation. And because we exceed the time allowed to us as well, we are going now to move to the next speaker. We are going to be in Agadir as well with Mr. Munir Birouk. Dr. Munir Birouk is a professor of comparative literature at University Ibn Zohr in Agadir. His research interests are the field of literature, ethics, and contemporary Arab Islamic thought. His PhD thesis was on the thoughts of the Moroccan philosopher Taha Abdelrahman. And his a paper is entitled Human Rights After the Palestinian Deluge. Who is the human? Who's right? The floor is yours, Mr. Birouk.
Thank you. Assalamu alaikum wa rahmatullahi ta'ala wa barakatuh. Thank you, Dr. Shaib, and welcome, although virtually in Agadir. Let me first start by thanking and extending my thanks to the scientific committee and organizing committee of Imam Abdessalam Yassine Foundation for Research and Studies for holding such a significant but also very timely event. Indeed, very timely. My presentation, as I said, I titled my presentation as "The Human Rights After the Palestinian Deluge," and let me get straight into the topic. So, that human rights today are conferred and distributed unevenly, and at will and randomly, selectively, is no longer a matter of contention, especially after Gaza side or indeed Gaza sides in the wake of October the 7th. One of the manifestations of the Palestinian deluge is sweeping away the already shaky faith in so-called in human rights as promoted and celebrated by the liberal democratic West as being universal and inalienable. In this presentation, I argued that the discussion about the dilemma of human rights today should go beyond bemoaning and weeping over or bemoaning the Western double standard approach to human rights, a point at which most analyses linger. Rather, what is required, in my view, is understanding the underlying causes of the flagrant discrepancy between the Western humanitarian discourse and its random and overtly biased practice. That is, go beyond bemoaning double standard approach and looking or tracing the root causes, philosophical causes which underlie and underpin such standard bias. Such bias, overt bias. In this paper, or this presentation, also contend that the current historical moment, disconcerting and traumatizing as it is, may and indeed even should constitute an invaluable opportunity for dramatic shift towards radical revision of the current Western-dominated human rights system and the reconstruction of truly an authentic universal human rights paradigm. Let me first start with the obvious of double standards, right? So there is no contention, as I said, about the selective treatment and application of the international law and rights. Israel has always acted as a rogue state, committing all manners of violations and crimes, yet still enjoying impunity. Suffice it to say that Israel today is the only extant settler colonial project in the 21st century. One of the ironies of fate, right, concerning or just as far as human rights are concerned, is that the Universal Declaration of Human Rights issued in 1948 was issued in 1948, the very same year of the foundation of Israel, of the State of Israel, at the expense of the forced displacement of indigenous Palestinians, called termed Nakba. So these violations are not the outcome of are not very recent. As you know, they existed even long, just perpetrated even long before the current horrendous war crimes in Gaza. They include rights. Just to cite a few examples, city settlements, annexation of lands, crimes against humanity, genocides, tumbling after each other, forced displacement, indiscriminate bombing of hospitals, health facilities, places of worship, cutting off water, food, and electricity supplies, also bombing areas previously declared safe by the Israeli army itself, not to mention targeting journalists, ambulance crews, and relief trucks, and the list goes on. So now, here is the rub of the thing right now. Compare the slow, reticent condemnation, right, the Western reticent condemnation and even justification sometimes of these gross crimes with the American and European prompt positive reaction to the Russian attack on Ukraine. And the double standard is so flagrant. Selective, also double standard approach is manifest in a selective support of and identification of resistance and liberation movements. While Palestinian resistance movements are labeled as terrorists and put on blacklists, legitimacy is imparted in resistance movements on certain or other resistance movements elsewhere as well, and at the will of the international community. Take, for example, PKK, for example, in Turkey, or other examples as well. So all of that erodes, actually contributes to the erosion of the credibility, not only of the West, but of human rights system as well, which I still believe it's one of the outstanding achievements of humanity, but it has to be upheld and updated. The values and the values, principles, and institutions of international humanitarian law are being eroded, right, systematically and persistently with every strike on helpless innocent civilians in Gaza Strip. Now, these barefaced and shameless and one-sided application of human rights begs the following questions. Who is a human indeed? We say human rights when we state human rights. Who is the human? What human is intended? And who is the human who is intended by human rights? And whose rights and whose justice are we talking about? And here I borrow in writing my title, right, whose rights and whose justice, you know, the Alasdair MacIntyre's title of Alasdair MacIntyre's book, Whose Rationality and Whose Justice, right, which is not too far indeed from the today's topic. Jacques Rancière actually, right, spoke about, right, the French philosophers spoke about this distribution of the sensible. Here, the distribution is an unequal and uneven, right? It is whose right, whose justice, whose rationality, whose duties indeed. And this is the core argument of my paper, is that the present conundrum of human rights and its inefficiency is not only political and practical, that is not only related to application, it's not a matter of application, but it is structural. In other words, the seeds of the Western blatant and outright partial distribution of rights are to be found in the genesis, very genesis, and underlying philosophy and politics of human rights. Let me start with the underlying philosophy of human rights. And, you know, it goes out of saying that human rights today is grounded in the ideals of the Enlightenment. But here is one problem, is that the ideals of the Enlightenment philosophy, right, or thought, as many decolonial philosophers explained and elaborated, is trapped by a paradox. And this paradox entails a duality of humanism and discourse about humanity, about humanism, toleration, autonomy, liberty of the individual, and on the other side, undercurrent racism, which runs through and infiltrates the thought or the subtext of the Enlightenment philosophy. Let me start with cite few examples. For example, Immanuel Kant. This is a forefather and inspirer of cultural human rights and international law, right? But in the thought of Immanuel Kant, who's the memorable, or whose memorable expression we all recall is right, Sapir Ode, right, speaks about the autonomy of the individual, international, of human dignity, of toleration, autonomy, rationality, etc. But is at the same time unabashedly, right, or at the same time unabashed racist views straddle his anthropological writings at the same time. Kant talked about people of color's lack, for example, of talent and capacity for civil government, in the same breath and in the same way as he talked about the conditional dignity of human beings, right? Just for that, for more detailed, consult his anthropological writings, for example, on his essay on the different races of man, and also his essay on national characteristics. There is Immanuel Kant himself, of course, as well, was indifferent to the problem of slavery, and this has to be explained. In no place in his writings? Was he vocal about, problem with slavery, especially that he was writing in the wake of the transatlantic trade in the 18th century? Second figure is Thomas Jefferson, who the founding father of the United States and author of the famous sentence, "All men are created equal," in the Human Rights Declaration, United States Human Rights Declaration. So Thomas Jefferson was a slave owner, was himself slave owner of hundreds of slaves in his working in his plantation, and his views also about black people are no less racist, biological. He holds or just used to hold or just held biological and intellectual views about the biological and intellectual inferiority of the black race. Even Sartre, Jean-Paul Sartre, who managed actually to escape the racial syndrome, was so short-sighted to perceive or to understand how apartheid politics are waved into the Zionist practices in Palestine. For more details on that as well, the reader might refer to the testimony of Edouard Said about Michel Foucault, Sartre, and de Beauvoir's attitudes towards the Palestinian, or about the Palestinian question. One of the recent intellectuals, also one of the celebrators indeed of the Enlightenment thought, is Jürgen Habermas, right? Who didn't shame, right, from writing a statement in which he made explicit his post-Zionist attitude in a famous statement he published in the aftermath of the October the 7th events, right, titled, I still remember, Principles of Solidarity. And as a researcher put it, a colonial unconscious running through successive generations of the Frankfurt social critical theory. Habermas used to speak at a public sphere about the ethics of dialogue and conversation in a public sphere, about the respect of the other, and his view about democracy. Indeed, he was one of the late celebrators and promoters of the Enlightenment. We still remember his debate with postmodernists. But actually, even Frankfurt School, which promoted critical theory, cannot fully fully succumb to that great racist subtext.
Mr. Biruk, you still have 3 minutes.
3 minutes. Okay.
Yes.
So,
thank you.
Okay. On another note, the exclusion of history is one of also the problems of human rights system. The Enlightenment emphasized the reason and autonomy over the weight and dogmatism of tradition. A human rights approach is characteristically pragmatic, concerned with the present violations and perpetrations. And this is, I think, a problem because it is an atomistic view and deconceptualized approach which overlooks history and the genealogy of the conflict, right? Concentrated in the moment, forgetting or just turning a blind eye to the history and genealogy of the conflict and of the problem. And hence the insistence of in media outlets and speakers, Western speakers and diplomats on the insistence on the 7th of October as the point of the outbreak of the conflict, right? Ignoring the long 70 plus history of occupation and subjugation. Another problem also is the indictment of violence, right? We in human rights reports denounce violence regardless of the context and of its context and intentions. Not all violence indeed could be denounced because some violence or certain aspects of violence are aimed towards establishing justice, for example. So this decontextualized neutral framing of violence, this concentration or just focus on the what and how violence and not its why, obliterates power imbalances, for example, between the occupier and the occupied, the aggressor and the resistant. For human rights institutions, for example, it makes almost no difference whether violence is an act of perpetration, an act of resistance, or an act of undoing justice. NGOs, for example, like Amnesty International and Human Rights Watch, documented and denounced abuses by both Hamas and Israel. And this creates a false equivalence, equating Hamas's killings, for example, on October 7th, with Israel's disproportionate retaliation, which involved blockade tactics and caused mass civilian deaths. There is a human rights report which was issued on 17th of July 2024, right, whose title reads like that: October 7th crimes against humanity, war crimes by Hamas-led groups. Imagine, right, equating or falsely equating the killings on that day with, and labeling them as wars against humanity with Israel's Israeli war crimes. These instances of the oppressed, and there are instances of the oppressed and occupied fighters who were previously labeled as terrorists, but later became recognized as legitimate resistance movement. For example, the Irish Republican Army, IRA, and the Algerian National Liberation Front, the African National Congress. All of them were labeled as terrorists, but they are fighting for their freedom of the land, freedom of their people. But today they are recognized as legitimate, resistance movements. Now, by ignoring history and neutrally framing violence, human rights reporting just obscures structural oppression and equates the victim and the perpetrator. Another problem, right? And let me finish with that. The law, and I thought, is it the law, the force, or the force of the law, which governs governs human rights system? Do the principles of international law express the law force or the force of the law? And plain flagrant cases, what happened after October 7th is a plain and flagrant case of how power trumps law. Human rights are enforced selectively based on geopolitics. Sometimes human rights selectively, right throughout history, human rights, it transpires, are selectively or have been selectively employed as a means of pressure and domination. For example, the case of Iraq, China, Russia. Sometimes even the human rights discourse is used to justify intervention in the cases of Iraq and Libya. Israel is largely enjoying impunity. History of the Western commitment to maintain Israel as colonial settler project in the Middle East is just a plain case in that respect. Okay.
Mr. Baruch, I'm sorry, we're gonna have to stop you.
Okay, I will maybe.
I want to be severe, but
no problem. Right, you're welcome. Maybe we will leave 2 or 3 points till the discussion, inshallah. Right, it's okay. Thank you very much.
Thank you very much, and we will be thankful if the committee receive your paper to be published later. Okay, now let's cover a very long distance and thousands of miles to reach New Delhi in India. And we are happy to have with us Mr. Ashif Mekden, who is a research student in India, in Indira Gandhi National Open University in New Delhi, who will deal with human rights and freedom in diverse society states, peculiarities shape implementation. I hope it's not too late there in New Delhi, and you are welcome. Marhaban, Khush Amadid. Khush Amadid, you are welcome. Mr. Ashif. Mr. Ashif Mekden, the floor is yours. I think we have a technical issue. Mr. Ashif, are you with us? Are you here? Mr. Ashif Mekden. Okay, if Mr. Ashif Mekden is not here, let's move to the fourth speaker, and we will be back to Mr. Ashif once available. So let's move to Mr. Mujib Rahman, the last speaker. Mr. Mujib Rahman, also in New Delhi, who will talk about minority education challenges in India, a special study on Muslim minority. Mr. Mujib Rahman, are you here with us? Mr. Mujib Rahman? Okay, either Mujib Rahman or Ashif, the one who is available.
Hi, I'm here.
Yeah, okay. Okay, welcome.
Thank you.
Khush Amadid to you as well, in your language.
Okay. Thank you to all to address this program, especially chairperson, honorable panel members, distinguished guests, and dear audience. Assalamu alaikum wa rahmatullahi ta'ala wa barakatuh.
Wassalam.
To all of you, it is indeed a great privilege and honor for me to stand before this estimated gathering to present my research paper in this program. Firstly, I would like to present in this program about the Islamic about the PPT you can see here. Firstly, minority education challenges in India and special study on the Muslim minority. This is my topic. Firstly, the India, one of the world the most populous countries, also has the largest minority population. However, the present situation of minorities in India is concerning as the continue to face various forms of oppression, social, economic, cultural, and educational. This is partly due to the current government's failure to uphold the constitutional rights enshrined for minorities. Among these groups, the Muslim minority is particularly affected, suffering from the communications and discriminations. In this context, it is essential to explain the major educational challenges facing the Muslim community in India today. Then I would like to present a title to here, Education System in India. Firstly, the education system is India. Primary education in India is free and compulsory for age 6 to 14. It includes lower primary grades 1 to 5, focusing on basic literacy and numeracy, and upper primary grades 6 to 8 with the expanded subjects like science and social studies secondary. Then the purpose students to boards exams, while higher secondary grades 11 to 12 allows specialization in science, commerce, or humanities. And after the grade 12, students enter a higher education, including the undergraduate, professional, and research programs India has a vast network of institutions, and entrance exam is essential for admission to many reputed universities and colleges across the various fields. Then the second, introducing the education system of Muslims in India. Firstly, the basic education institution of Muslims in the name of madrasa. This is the basic of Islamic studies. They are giving more points about the Islamic history and other Islamic Quran recitation and other. The second model of Islamic institution, the oath in the name of in the language of Malayalam, Othupalli or Maktab. It is the most attached elementary school in Kerala where Imam teach about girls basic Islamic knowledge, including Quran recitation, Arabic and prayer rituals. Teachings or supported by assistant like the Mullake. Though many were converted into formal school during British rule, they still function as centers of Islamic education before or after school halls. The third model of Islamic institution is Palidars. This is a residential mosque-based system where students live, study religion, and are fed by local households. In return, they teach younger children, creating a unique community-driven education model. Modern courses now including computer skills and core curricular learning. The fourth model of Islamic education system, the Islam Arabic College, offer both religious and secular education up to postgraduate levels, blending Islamic studies with the modern pedagogy and infrastructure. The last model of Islamic studies institution, the Islamic universities. This is an institution affiliated to international bodies and offering advanced education, include research level courses like the Jamia Jalaliya Darul Huda. Then there have more Islamic boards, official Islamic boards like Samstha Kerala, Madhya Board. This is providing more modern academic course for Islamic students, like more education in Quranic recitation and Islamic history and others. I am introducing introducing constitutional provisions for education of minorities. We know that there have the Indian Constitution provides several provisions of minority education and development. Articles 40 to 31 ensure the equality and non-discrimination, while Chapter 14 emphasizes the free quality education for all regardless of caste, community, or gender. Key articles protect minorities education rights, such as the Article 29 to 30, and ensuring the right to establish institution, converse, culture, and receive the education in their mother language. After that, I am introducing the firstly the who are the about the religious minorities. We know the Indians will have more religions. Then there we can see two minorities model. One of them the language minorities and religious minorities. I introducing the religious minorities about the religious minorities. This the National Commission of Minority Act has notified five religion communities as minorities: Muslims, Christians, Sikhs, Buddhists, and Zionist Parsis. In Jains were also included as religious minorities as per census 2011 figure 20.2% of our population belongs of religious minority communities. Muslims constitute 14.2%, Christians 2.3%, Sikh and 1.7% Buddhists. After that, I would like to I represent I introducing the main point of my paper, the challenges faced by Muslim minorities in India in education. Then there have more there have more challenges faced by Muslims in India in education. The Muslim minorities in the face by numerous education challenges that head up their academic progress. The one major issue is syllabus reform, where significant parts of my Muslim history, such as the Mughal era, are being removed and replaced with the basic narratives promoting communal hatred. After that, the second challenge is the certificates are being removed and replaced with the basic narratives, and the certificates the certificates of Islamic or un-Islamic minorities institutions, especially madrasas, are of the encouraged bearing students from pursuing higher education of employment. The secondly, education centers
Mr.
like
Mujib,
that's
Mr. Mujib Rahman,
uh,
I'm sorry for being severe. You still have 1 minute because the third session is normally scheduled at 6 to 10 minutes. So we are left with another presentation. Please, if you can end in 1 minute, please.
okay. The third challenge is the discrimination of in classrooms that have more children and teachers discrimination their friends or teachers. And the another one is clothing refusal. The more the big no the Karnataka Sarkar refusal the hijab in the classrooms for Muslims, and the another is the another challenge is lack of scholarship and counseling. We know there have more Muslim students in village. There didn't give the Sarkar the scholarship and counseling for this. And the last is the timing, the innovation class and exam trainings, especially during the students to hold the studies. And especially during Friday prayers, create additional barriers. Despite the government directives, many schools ignore the needs of Muslim students making here. The education system increasingly exclusively minority education institution of the struggle with the independent research, including the unaffected teachers. The lastly, I introducing a report by on the the name of Sachar Committee report about the Muslims. There have more points. I would like to say something. 25% of Muslim children from the children 60 to 40 years have never attended school or dropped out. The second point, very low Muslim representation higher education, one into to define, understand, and undergraduate in the
Mr.
in
Mr. Mujib,
um,
thank you very much. Thank you very much. We are sorry for interrupting you. Thank you for your presentation. Now, let's move to Mr. Ashif Mekden, who had a technical issue. We hope he is now with us. Please, you have 10 or less than this, 10 minutes or less, because the other session will start soon. Thank you. You have the floor, Mr. Ashif Mekden.
السلام عليكم ورحمة الله تعالى وبركاته. الحمد لله
وعليكم السلام.
والصلاة والسلام على أشرف المخلوقين وعلى آله وصحبه أجمعين أما بعد. Here I am discussing about human rights and freedoms in diverse societies, how society peculiarities shape implementation. Here we know human rights are fundamental entitlements that belongs to every individual, regardless of nationality, ethnicity, religion, or political affiliation. They are universally recognized as the basic conditions necessary for individuals to live with dignity, freedom, equality, and justice. These rights encompass both freedoms and protections, including the right to life, freedom of speech, and the right to a fair trial. safeguarding individuals from political, social, and legal abuses. The Universal Declaration of Human Rights, adopted in 1948, serves as a cornerstone of contemporary human rights law, emerging from the devastation of World War II. The Universal Declaration of Human Rights articulates 13 articles that outline fundamental rights to be protected across the globe. A core principle of the UDHR is its universality, asserting that these rights are inherent to all individuals simply by virtue of being human. Subsequent agreements, such as the International Covenant on Civil and Political Rights, that means ICCPR, and the International Covenant on, Economic, Social, and Cultural Rights, have solidified these norms, transferring them into legally binding obligations for ratifying states. These covenants address distinct aspects of human rights, focusing on civil and political liberties as well as economic, social, and cultural well being, thereby reinforcing the indivisible and inalienable nature of human rights, which transcend social and national boundaries. A central debate in human rights discourse revolves around tension between universalism and cultural relativism. Universalism posits that human rights are inherent to all individuals and should be applied uniformly across all societies and regions, as emphasized in foundational documents like the Universal Declaration of Human Rights. Proponents of universalism argue that human rights establish essential standards of dignity and liberty that surpass cultural or regional differences, protecting individuals from severe mistreatment and discrimination worldwide. Conversely, cultural relativism contends that human rights must human rights must be mistreatment must be interpreted within the context of specific cultural, religious, and social values. Advocates of this perspective argue that local customs, beliefs, and tradition shape people's understanding of justice, gender roles, and freedoms, making an uniform approach problematic. For example, concepts such as individual autonomy and freedom of expression may not align seamlessly with collectivist societies and priorities community obligations over individual rights. This tension becomes particularly salient in discussions concerning women's rights, religious freedoms, and LGBTQ rights, where local beliefs and practice can conflict with universal human rights norms. Critics of universalism argue that imposing a standardized human rights framework is cultural dominance and disregards the autonomy of local communities. Conversely, universalists argue that relativism can excuse abuses under the guise of cultural uniqueness, potentially leaving individuals vulnerable to practice like gender discrimination or child marriage. Navigating the balance between universal human rights standards and cultural difference remains a complex and ongoing challenge. Achieving this balance necessitates respecting local traditions while ensuring that all individuals enjoy the fundamental rights and protections outlined in global human rights instruments. The central question of how unique state characteristics influence the practical implementation of human rights is a key concern in contemporary human rights discussions. How to reconcile universal standards with specific local contexts. While human rights are widely recognized as fundamental entitlements inherent to all people by virtue of their humanity, the manner in which each state implements these rights varies considerably. This variation arises from a complex interplay of factors, including cultural norms, legal traditions, political structures, economic development, and social values. Firstly, cultural norms exert a strong influence on a state's approach to human rights. In some societies, communal values may take precedence over individual liberties, creating tension with human rights frameworks that emphasize individual autonomy. For instance, collectivist societies might perceive certain rights related to freedom of expression and privacy differently than more individualistic societies, leading to divergent applications of these rights. Secondly, a nation's political and legal systems play a crucial role. Democratic states with established rule of law tend to have robust legal frameworks for safeguarding human rights, whereas authoritarian or unstable regimes may restrict these rights to maintain control. Furthermore, the presence of institutional mechanisms such as independent judiciaries or human rights commission often determines the effectiveness of human rights protection within a country. In economic conditions also significantly impact the ability to uphold human rights standards. Wealthier nations with greater resources can typically invest more in ensuring the realization of rights. For example, through accessible healthcare and education compared to economically challenged nations. This disparity raises critical questions about equity in the fulfillment of human rights across diverse economic contexts. In conclusion, we know while the concept of human rights aspires to universal applicability, local factors such as cultural beliefs, governance structures, and economic resources contribute to varied expressions and implementation. This complexity underscores the needs for a nuanced approach that considers local realities when addressing global human rights issues, striving for a balance that aspects universal principles while acknowledging unique state circumstances. When we know the cultural influence shaping human rights perceptions. Social relativism posits that human rights and moral standards should be interpreted within the context of individual societies, asserting that no single culture's norms are inherently superior. In contrast, universal human rights advocates propose that certain rights, such as freedom from torture and the right to equality before the law, are applicable to all individuals regardless of their cultural setting. This debate has emerged because some practices defended as cultural traditions directly conflict with these universal benchmarks, creating tensions in global human rights dialogues. In many East Asian societies influenced by Confucian principles, communal harmony and family hierarchy are often prioritized over individual rights. This cultural perspective can influence authorities and discourage criticism of the government or senior family members, which may result in restrictions on freedom commonly recognized as human rights, like freedom of speech or the right to challenge authority. For example, certain Asian governments justify limiting this opportunity as essential for preserving social stability and respecting traditional values, which sometimes culture and application of
Mr. Ashif,
universal.
Mr. Ashif, if you can end your presentation in 1 minute, please. 1 minute,
1 minute.
please. Yeah, not more than this.
Okay. Now we can go to conclusion. In the conclusion, we know in light of the diverse cultural and political landscapes across the globe, international organizations and local governments must prioritize human rights in their policy making process. While the universality of human rights remains a cornerstone of global justice. Recognizing and respecting cultural and political nuances is equally important. This acknowledgement is not merely a gesture for tolerance, it's a pragmatic necessity for effective implementation. Local governments have a unique potential to implement innovative initiatives that directly reflect the needs and values of their communities, thereby enhancing the protection and promotion of human rights on the ground. This grassroots approach allows for policies that are more contextually relevant and likely to garner local support, fostering a sense of ownership and responsibility among citizens. Examples of such initiatives might include culturally sensitive programs addressing gender-based violence, community-driven projects promoting economic rights, or localized educational campaigns tailored to specific cultural understandings of freedom expression. Simultaneously, international organizations should support these local efforts by providing overarching frameworks that allow for adaptability and responsiveness to specific contexts. That involves moving beyond perspective, top-down approaches to embrace a more collaborative model. International bodies can offer technical assistance, funding, and platforms for sharing best practices, while also respecting the autonomy of local governments to tailor human rights strategies to their unique circumstances. A collaborative approach that effectively marries universal human rights norms with local realities can create more effective and inclusive policies.
Thank
This
you so much.
balance,
Thank you so much, Mr. Ashif McDin. We thank our guests, our speakers. We also thank the organization committee of this session of the whole conference, and hope see you in the future, inshallah.